The characterization of property as separate or community property determines its ownership, each spouse's rights, and whether it's subject to division between the spouses in a divorce. Recall that property is usually characterized at the time of its acquisition based on the property's source. And once property is characterized, it retains that characterization even if it changes form during marriage. But sometimes spouses might want to change the characterization of property. To do so, they'll use a transmutation agreement. A transmutation agreement is a postnuptial agreement in which spouses agree to alter the character of separate property to community property to separate property, or one spouse's separate property to the other spouse's separate property. It can be used to change the characterization of property that has already been acquired, or the characterization of property that will be acquired in the future, such as wages. There are three key requirements for the formation of a valid transmutation agreement. First, the agreement must be in writing. Second, the agreement must contain an express declaration of intent to alter the characterization of property. And third, the agreement must be signed by the spouse whose interest is adversely affected. Imagine that when a husband and wife marry, the wife owns a home that is completely paid for. That home is the wife's separate property. The spouses live there during their marriage and eventually decide that the house should be characterized as community property. A transmutation agreement making that change to the home's characterization will only be valid and enforceable if it's in writing and contains an express declaration that the spouses intend the separate property home to be characterized as community property. The agreement must also be signed by the wife because she's the one whose interest is adversely affected by converting the home to community property.